Welcome to the Master Builders Victoria podcast. I'm your host, Sam Smith, Director of Advisory. Master Builders Victoria was established in 1875 by a group of distinguished builders intent on raising standards within the industry. Since that time, the organisation has grown to become a preeminent voice with members universally renowned for their reliability, skill and professionalism. Today, Master Builders Victoria aims to lead a future-ready industry that builds a better world. During this podcast series, we bring industry experts directly to you to discuss trends and challenges within our industry to empower people to build a better future. Today we are joined by Monique Burns, Senior Legal Counsel and Legal Manager at Master Builders, to talk about the review of the Domestic Building Contracts Act in Victoria. In 2023, the Victorian Government announced a commitment to a range of reforms for the construction industry. This included reviewing a key piece of legislation that governs domestic building in Victoria, the Domestic Building Contracts Act, or DBCA. The review aims to ensure it is fit for purpose and to strengthen protections for consumers while supporting the needs of the building industry. As part of the review, government began consultation with industry, inviting answers to 26 questions across the current legislation and allowing input and feedback on where the legislation could be improved. Master Builders Victoria played an active role in this review. Monique, welcome to the podcast. Could you tell us a little more about how MBV contributed to this review? Was there work behind the scenes here?
Thanks, Sam. Absolutely. As you've already said, MBV played a very active role within this review. Our legal team has years of anecdotal data relating to pain points or difficulties within the legislation as it currently stands. We see firsthand how the legislation is interpreted in the industry, how it works and how it doesn't. That gave us a pretty strong starting point for the review. Additionally, our policy team ensured that we developed a working group comprised of our domestic builders across volume builders, small builders and apartment builders. We also invited our members to fill out a survey which was linked to the questions asked by the review.
Can you speak to us a little more about some of the questions the review posed and how we answered them?
Yeah, absolutely. One of the key areas of our focus was around what is considered to be domestic building work. And I know on face value that seems really simple, but the way that the Act defines this is actually important. It provides us guidance with what kind of work is covered under the legislation, as well as the associated obligations and liabilities.
So what is domestic building work then?
So if we put it simply, currently it is defined as any work referred to in Section 5 of the DBCA and works which are not excluded by Section 6. Now, Section 5 is quite broad and it encompasses usual works that you would likely associate with domestic building work, such as the construction of a home, associated works, renovations, alterations, demolition, etc. For us and for our members, that's fairly straightforward. But where we start to see the pain points are in these grey areas that we have. So within our review, we've asked for a little bit more clarity around the extent of Section 5, including a clearer definition of the word home, more insight into what those excluded works are, and greater understanding as to how this fits into what works need to be completed under a major domestic building contract and those which don't.
You make mention of a major domestic building contract. Is there a threshold or criteria when this takes effect?
Yes, there is. And bear with us here. I know I'm mentioning lots of parts of the legislation, lots of sections. I know it's a little overwhelming, but I will explain what I'm talking about. Currently, the legislation sets out that for any works which are considered domestic building work, they need to be completed under a compliant major domestic building contract once the value of those works hit $10,000, and the builder needs to hold the appropriate registration for those works. Once those works hit $16,000, we need to obtain DBI, or domestic building insurance. Now, Master Builders has recommended in our response that we increase this threshold to align with the current monetary threshold that allows for a 5% deposit. So right now, that's $20,000. The monetary thresholds that trigger the requirement for a major domestic building contract and domestic building insurance need to be raised to reflect the rising costs of building supplies, trades and materials. Master Builders Victoria have supported the reforms to increase the DBI threshold to $20,000 in the consultations that we've had with the Department of Energy, Environment and Climate Action. Aligning these thresholds will also streamline the contracting process for domestic building works and prevent confusion that we're seeing arise over what contract values trigger what conditions. Outside of this, something that we really hear a lot of chatter about from our members is something that's commonly referred to as an early works contract or a preliminary works contract.
10,000, 16,000, 20,000. Sounds like we're at an auction. Certainly some consistency there might be useful. Now, hypothetically speaking, if I had a friend that didn't know what a preliminary works contract was, how would I explain it?
Your friend would be in good company because right now we don't have a defined term under the legislation for a preliminary works contract. We're kind of filling in some gaps here with that language. Generally though, what we would consider preliminary works to be is those which are less than $10,000 or those works which are excluded from the current legislation and therefore are not required to be completed under a major domestic building contract. We know that this is causing confusion for our members. We know that people don't exactly understand how it works or when it works. And so that's why one of the key areas of our submission to government focused on seeking greater clarity around the definitions of domestic building work, which in turn will allow us to have greater understanding of the works which are not governed by the legislation and therefore which works can be lawfully completed under a preliminary works contract.
There's a lot of ins and outs there in terms of what's included, what's not. What sort of work have you seen included as part of preliminary works?
Look, it can be varied. Typically, these are the kind of works that are undertaken by a builder prior to being ready to begin construction. So this can include things such as the preparation of plans and specs, obtaining our soil reports, foundation data, and other activities that can assist a builder in estimating the overall price of a build.
What recommendation did we put forward in respect of preliminary works?
Again, our focus was around clarity. MBV really wants to see some clarity around the works that are identified as preliminary or preparatory works. We believe that this work should not require a major domestic building contract. The DBCAA should be amended to more accurately reflect the risks and financial burdens that prelim work imposes on builders. This amendment should include a more precise definition of what constitutes a preliminary agreement, thereby providing greater clarity and protection for both builders and consumers. We proposed that work that would ordinarily or reasonably be performed by a builder to prepare and cost what will later become a major domestic building contract should not require a major domestic building contract.
Now, I know the review also focused on progress payments and deposits. Can you speak to us more about why this was an important focus for the submission?
Yeah, absolutely. If I break it down into two areas of focus. Firstly, with our progress payments. We know that the progress payments under Method A, which constitutes of our predefined by the legislation stages of building, don't accurately reflect our current state of building. We wanted to ensure that the Act was updated to reflect building in 2023, 2024 and beyond. An example of this is the definitions around fixing stage, for example. All of our members say that despite what the legislation says about that definition, how they currently work differs. Why this is important is because currently under the Act, a builder is not allowed to invoice until works are completely done, finished, nothing left under those definitions. So technically, a builder cannot invoice for works until they've completed all of that. So if our builders are telling us that these definitions don't accurately reflect the works they're doing, they're holding off on invoicing until much, much later in the build, which makes the financial risk greater for them. That's progress payments kind of as briefly as we can make it right now. If we move over to deposits, our deposit limits, again, were made when the legislation was made some time ago. And we all know, cost of living has increased dramatically.
So this legislation, it's the Domestic Building Contracts Act of 1995?
Correct.
Has there been any reviews since then?
Look, legislation always has the ability to be changed and updated, but this is the biggest review that we've seen in some time.
And certainly so, I guess a system of work that we had in place nearly 30 years ago now is well and truly due for some improvements, some refreshment.
Yeah, absolutely, which is why we really supported the government's initiative to make this review happen.
Builder cash flow remains a critical issue, exacerbated by high upfront costs, rigid distribution of stage payments, and inflexible fixed-price contracts. Did the review focus on enabling builders to recoup some of the unexpected costs that arise during a build?
Absolutely. Sam, you might remember that Master Builders has been really vocal about cost escalation clauses for some time. We actually started during COVID when we noticed how much our builders were struggling with cash flow and with unexpected costs that would arise during a build. That hasn't changed. We did also put a focus in this review on cost escalation clauses and again showed our support for them. Now, we don't expect that cost escalation clauses should be a free-for-all by any means. We know that we want to protect our consumers in the build as well. However, we do think that there is an argument to be made for the inclusion of cost escalation clauses being allowed in some circumstances. For example, if something does occur that a builder could not plan for. Perfect example being the COVID pandemic.
You often talk about it as builder's warranty. What exactly does this refer to?
This is definitely a question that we get a lot in the legal team. There's some confusion because warranty is thrown around, although it does refer to two separate concepts. So firstly, let us begin at Section 8 warranties. Our Section 8 warranties are the promises that the legislation makes on behalf of a builder. Now, this includes things such as ensuring the building is fit for purpose, that new materials are used unless otherwise specified, etc. These promises exist for 10 years and they survive with the building, which means that your promise to the owners extends to any other owner that has the property within that period. On the other hand, we have warranty insurance or domestic building insurance, DBI. As a builder, if your domestic building works exceed $16,000, you must purchase this before demanding or accepting any money under a contract. Now, in recent times, we have seen very harsh penalties imposed on builders who do not comply to this requirement. This insurance is to protect the consumer only in the event that their builder dies, disappears, or goes insolvent. The owner then is able to claim against the insurance for incomplete or defective works. Now, in terms of Section 8 warranties, we do have some pain points around that. When we look at, for example, one of the Section 8 warranties, it states that a builder warrants that the work will be carried out in a proper and workmanlike manner in accordance with the plans and specs set out in the contract. Master Builders has suggested that this warranty only extends to the works which the builder is completing. For example, we are saying it should exclude works which are shown on the plans but which are not included in the builder's scope of works. So we might see that happen, for example, if there is a pool on the plans but the owner is directly engaging another builder to complete it. We're saying we don't think that our builder, under a Section 8 warranty, should have to warrant that those works have been carried out in a proper and workmanlike manner.
Does the role of the consumer come into play at any point?
Yeah, absolutely. Master Builders Victoria strongly believes that efforts should be made to improve consumer education and awareness about their rights and responsibilities when entering construction contracts. Access to educational resources and guidance can empower consumers to make informed decisions and navigate the construction process more effectively. And ultimately, builders and owners are working together for the shared outcome of a great build.
Now, there's been a lot of legal language thrown around today, and there's certainly a lot more included in contracts and insurance policies. A well-informed consumer is often better for builders. When consumers have a good understanding of the construction process, it facilitates collaboration, better communication, and ultimately leads to higher quality outcomes. What can builders do to make sure the consumer has accurate information?
Look, I definitely agree that there is a lot of legal jargon for consumers to navigate. That being said, the Master Builders contracts are drafted in a way to be as user-friendly as possible. Again, we encourage consumer education and a better informed consumer does lead to greater outcomes. However, I do caution our members in ensuring that they're not providing any legal advice to owners. Now, by all means, they can answer questions about the works and their obligations. They can speak to the owners about what the job will look like, what it will entail, but the consumers should be seeking their own independent legal advice in the event that they need it. Builders also note that they must provide consumers with a copy of the Domestic Building Consumer Guide before they sign a major domestic building contract. This is available from the Consumer Affairs Victoria website, and it's also provided with the contracts that Master Builders Victoria sells. Now, with the Consumer Affairs Victoria, or CAV, website, they also have a number of resources which are really useful for consumers, including detailed information for them about building contracts, including when you must have a written contract, liquidated damages, unfair contract terms, and guidance on accessing dispute resolution.
So you've talked about the contracts. Some of these are available in a couple of different mediums as well. Here, there's a bit of fanfare about our eDocs platform.
Yeah, that's right. Look, last year we did launch our brand new eDocs system. If you've been familiar with our e-contract system, this is newer, better, faster, more user-friendly. We really do encourage members to give it a go. It's designed to make contracting easier, not only when you're filling the contract in, but also it incorporates the use of DocuSign. So no more having to sit there and hand signing page after page if that's not what you or your clients are after.
Now that's a member exclusive. So speak to our membership team and they'll sort you out with access for that too.
Absolutely.
Do you think it's likely the industry will see changes in dispute resolution services?
Look, this wasn't a huge focus of the review, but Master Builders Victoria did support additional funding and support to the Domestic Building Dispute Resolution Victoria, or DBDRV, as you may know it, so that it can continue to fulfil its purpose. This was created to be a quicker dispute resolution option. It was cheaper than VCAT and has a focus on shared outcomes for both the consumer and the builder. But it also allows for VCAT not to be overwhelmed with matters, which in turn means quicker access to resolution for those bigger and more complicated matters.
Now, as with all good contract discussions, terms and conditions apply. The review is still a work in process and it's not yet known what changes will be made. Do you know when the review will be finalised? Where are we going next with this?
Look, at this stage, we don't have a definitive date for the review to be completed. Currently, the information that government is putting out is that we should expect to hear something by late 2024. We do hope to see some positive changes when this review is finalised though, and these changes will have a positive impact on the industry.
You've covered a lot of information. Where can our members go to find out more or keep up to date with the review?
Look, we at Master Builders Victoria will most definitely keep you updated, so keep an eye out for our newsletters, our EDMs, our social media posts. As soon as we know something, our members will too. In the meantime, though, the advisory legal team is here. You can rely on us to assist you with your contracts, choosing a contract, understanding what the clauses mean, and understanding your obligations. Also, a little plug for our team, we have just launched our monthly contracts workshop. This is a really great tool for members either to refresh their knowledge on contracts or for new builders who want to learn everything that they need to know about contracts.
That contracts workshop sounds really good. Now, you're talking about some other contracts that we were offering earlier in one of your answers. What contracts do we have available for members?
Look, we've got quite a few. When we're looking at our domestic suite, we've got our new homes contract, which, as the name suggests, is great for those new builds. We've got our home improvement contract, which is almost identical to the new homes contract, but for a few clauses which allow for an existing property, such as some obligations on the owner to make sure the site is clear from rubbish. We have a minor works contract. We say that that contract is suitable for our smaller jobs. The contract does say for works up to $50,000 on it. That's not a legal limit, that's just a suggestion. That's really good for our smaller renovations. We also have the cost plus contract. Now with that one, I'm putting a big disclaimer, a big asterisk near it. That contract can't be used for all jobs. The legislation's pretty strict about when it can be used, and if you use it incorrectly, there are penalties associated with it. If unsure though, please give us a call first.
I think that last point is really important there about getting the right advice with anything contract related. Now, I'm not a lawyer. I have to disclose that as part of any legal or contract related discussion, don't we?
Absolutely. This podcast is general information only, is not intended to be legal advice, and should not be relied upon as so.
Perfect. But definitely the member engagement through our advisory team has helped inform our submission, both through the calls that we receive and through that engagement with some of the domestic builders too. Thanks for your time today, Monique. I found it incredibly valuable to gain some insights into areas of the Act that would benefit from change, as well as to obtain key insights related to our submission. And thanks to all those who've listened all the way through. If you have any questions about anything we've covered, you can send them through to legalinquiries@mbav.com.au or call us on 9411 4555. We'll be back again with another edition of the Master Builders Victoria podcast.
This podcast was recorded on Wurundjeri land. MBV pays respect to elders past, present and emerging.